When Julius first asked me to present this, I did want to use the subtitle. It's not always what you've got; it's what you do with it that counts. But I then ran that past my wife, who is my usual barometer for appropriate behaviour, and what she said to me was that was inappropriate. So I then decided that the best way to start to look at this was to go with the "Do you trust your wife" approach. Now, in the quite brilliant movie, The Shawshank Redemption, whilst being dangled several floors up off the edge of a factory roof, the prison inmate you can see here, Andy Dufresne, asks the rather awkward question of a stereotypically cruel prison guard, Captain Byron Hadley, "Do you trust your wife?" Morgan Freeman, playing another inmate, was reasonably confident at this point that the outcome would be a swift requirement for Andy to get hold of a well-known energy drink. But, spoiler alert, he survives, and the film goes on to win 7 Oscars. Now, in extending that question, and you'll perhaps allow me to move past perhaps precisely what he had in mind at the time. He alluded to the point that I'd like to talk about in this session, which is the question of whether or not there is a benefit to moving assets between individuals or entities to create a platform from which best to exploit them, and whilst at the same time offering them some form of enhanced protection. Now, in the movie, Hadley wanted to hide an inheritance from the US Inland Revenue Service, but the read across to brands and other intangibles is not a huge stretch. Now, I would have loved to play the clip here because it is brilliantly portrayed, but when I looked at it again online, I did realize the language is somewhat fruity, and that's even by the standards of some of the homeschooling debrief sessions I'm having at home. So I'll simply leave it as a recommendation for your next lockdown film night and move on. Now, Kelvin and Esther have already mentioned the idea of structuring in their discussions about valuation and licensing earlier this afternoon. So what I want to do is look at perhaps some of the, what could grandly call the housekeeping steps behind the subject in a little more depth. Now, at the heart of conversations around structuring, in essence, we are looking at how brands and other intangibles are held, and whether there are sufficient benefits to considering separating the ownership from the exploitation. And that is, can they be owned by one entity or individual and exploited by another? Now, the fundamental takeaway of this section of today's event is to take a moment at an appropriate point to think about this subject, because I fully sympathize with the fact that just right now people have got plenty of other things on their minds. But if there is a point in time to stop and reflect on the relative pros and cons of either moving rights or leaving them where they are, then I think that's time well spent. As with most things in life, there is no one-size-fits-all solution here. I've seen a number of situations where even seemingly well-planned arrangements are reversed in haste as a new pair of eyes has another look at them. A few years ago, I was involved in the reorganization of a rather well-known footwear brand, and they were looking to move their global trademark portfolio, it was over 100 countries, from the US to Europe. An extensive piece of work was undertaken by leading tax consultants. It was considered, it was signed off, and the button was pushed to green light at the project. Now, rather kindly, by the time it got to the lawyers, that instruction landed on my desk, or rather in my emails, the day after Boxing Day, with a request that it all be put in place by the 31st of December. As a lawyer, you often hear about that process and hope it never happens to you. But anyway, we rearranged Christmas holiday plans, and we got the job done. And that was notwithstanding the entertainment of trying to track down some of the signatory directors to ski chalets variously dotted around the globe. Those of you who were involved in that side of the process can then perhaps imagine what the re-registration costs were starting to look like. Then I suppose somewhat entertainingly, in the following October, we had a call to say that a new finance director had been appointed. He had looked at the scheme and didn't like it at all, thought it was unnecessarily aggressive, and he had spoken to the tax consultants, and they had decided that if we were able to unwind it before December the 31st in that same year, then the worst effects of the activity which we'd previously taken could be mitigated. So relieved that we had time to do it before the Christmas break this time, we pulled out all the paperwork and effectively reversed the deal. It was an expensive lesson learnt for the client. So in the words attributed once to Lewis Carroll's White Rabbit, perhaps a good phrase to have in mind for this sort of exercise is, don't just do something, stand there. Now, there's an opportunity to be unduly negative here to justify any actions. And for those of you scratching your heads around the graphics on the screen, it is true that structuring looks like it has potentially as much to do with death, divorce, and default as it does with managing unicorn-style success. But it's also important to remember that this is certainly not the preserve of either the biggest companies in the world or what I might unkindly call the trust and tonic brigade on the white sandy beaches of certain parts of the Caribbean. Now, the slightly exaggerated public view of using positions afforded by some of the more exotic tax havens around the globe is only one end of that structuring spectrum. By the time you've navigated global anti-avoidance regimes, which are increasingly tightening, more often than not, the steps taken are going to be far more modest. They're going to be less driven by tax and much more about positioning assets either for exploitation or protection. Hence, we move seamlessly from the palm-fringed tax havens, perhaps unfairly, to the perennially sunny shores of Northumberland coastline. So please remember, this is about taking structuring steps which are proportionate to your business to put you in the best position from which to both exploit and protect your brand. Now, whether the justifications appear more defensive than offensive, I would encourage you to look at these as two sides of the same coin. After the celebrated cyber hacks of the former law firm known as Mossack Fonseca, leading to the release of what were known as the Panama Papers, there are obvious side benefits to remaining conservative in your activities. Now, it's not to say that the tax-efficient options are not available, even if there is going to be a cost to moving the IP, and I know that there's some questions around transfer pricing and cost to move. There are certain tax regimes which can look very attractive. Think about Ireland, Singapore, Switzerland. They spring to mind, I know have been referred to earlier. It was also recommended that you find jurisdictions where the law is deemed to be robust and well recognized, certainly for enforcement purposes, which Julius will come on to talk about. But when looking at all the reasons why your brand valuation might be helpful to you, whether that's part of attracting external capital, a possible exit point by way of sale, or even a float, understanding how your brands really fit into your business is necessarily rather important. Once you know how critical they are to the business, that can act as a not so subtle prompt to ensure they're properly taken care of. Think about the valuable painting found in the attic referred to earlier. Of course, taking steps to ensure that your core trademark registrations are managed carefully is one thing, but given the vital role that they play, are you really doing them justice by leaving it there? Another perspective for that is, are you really sweating the assets hard enough? Now, as I'll touch on throughout this section, looking at what can be done to exploit brands often involves the act of ring fencing them in a place where what I will roundly call access to them is limited. The reason for this is to protect them, but the opportunity, as I said a moment ago, being the flip side of the same coin, that such a measure has to maximize exploitation should not be underestimated. For most businesses, brands sit within the operating company and no further thought is given to it than that. Registrations are made in the company name, and that's where most people expect them to be. But at the point in time where those intangibles become a valuable asset, is that the right place for them? If those intangibles are the venture's crown jewels, certain scenarios can arise that might dilute or even jeopardize that ownership. Now, I'm going to use brands and intangible assets interchangeably, so please take such references to include particular trademarks, patents, pieces of software coding or databases, really whatever intangible assets have key value to your business. The statistics for startup success at the first time of asking don't always make for very pleasant reading. let's consider a great idea for it going through its startup process. Now, it could be that the first iteration of that venture, or even a second, or even a third, might fail, whereas a later iteration may succeed. During that period of time, multiple intangible assets will have been created. Some will have been registered, some will have been purchased. Now, in many cases, little thought will have been given to where they're held, and that's not to be overtly critical. It's simply a natural consequence of there not being enough hours in the day to do everything required to get the business off the ground. Energies are simply directed elsewhere, following the essential mantra that cash is king, and we'll leave the idea that anyone talking about vanity of revenue and sanity of profit, that's a subject for another day. So the default answer is usually going to be to put the brand into a freshly minted registered company. It's neater, and after all, holding everything in that vehicle will protect against liability, right? But perhaps let's consider that for a moment. If we have a healthily grounded suspicion that until such time as a venture is proven, putting valuable assets which represent the core of that business proposition might put them at risk, why not hold something back? Esther has already described how licensing can provide great benefits with third parties, but is there a way of looking at that on an internal basis here? A registered trademark, retained by an individual founder, licensed on arm's length terms to his or her business, could ensure that if the first iteration or a later one fails, the mark doesn't fall into an administration fire sale, or perhaps even pass to the Crown as a destination of final resort. I spent some time helping the wife of a rather well-known French footballer playing in the UK Premiership structure a new UK-based apparel business. Now, it's fair to say that she lives a fairly distracted life on social media, so there was a strong possibility that of her not applying herself wholeheartedly to the business from the get-go was quite likely. The idea, however, was sound, and therefore we knew we were okay for investment funds from her husband, a fortunate position to be in, but we decided that the safer option might not be to put all of the IP in the business into the new company, but instead to hold it personally and for a short period of time, license it in until the venture was proven. Now, trying to explain the benefits of that was pretty clear and pretty easy, but it was a slightly more delicate explanation as to why we were doing it, because a conversation in which suggesting even politely that someone's cherished project may not succeed is not always best approached head on. Now, taking that sort of action is clearly a defensive measure, but also one that might help depress profitability and hence corporation tax exposure in due course, as well as delivering some revenue directly into the hands of a founder. The same question with a slightly different angle can be posed to more established businesses. Following the earlier discussion of increasing brand values, is there a case to be made for placing brands into separate companies and licensing them back to operating companies? So not using the third-party example of Esther's licensing, but actually bringing this within the corporate structure. There's an obvious caveat here, and it alludes to the question that was posed earlier online by one of the attendees wanting to know, did this involve transfer pricing and costs? Well, inevitably, it does involve a valuation cost. And therefore, this activity can really only be done at a time when those valuations, or the relevant valuations, make it financially and fiscally sensible to do so. But if, as alluded to earlier, we can ring fence IP, which is increasing materially in value, that could well help us if there's a material risk to the business, for instance, product liability issues. So if you had a product liability issue arising and a consequent claim, which might otherwise ruin the business through litigation, let's understand whether or not we've got some help that can be found through ring fencing IP in a company. If you were to lose material legal claims, especially in a high damages jurisdiction, that could mean the end of a perfectly good business and the consequent loss of such intangibles through liquidation or administration. Now, reputationally, few brands would survive that sort of issue, but underlying software code, business methodologies, recipes, they might all be able to withstand it. In one earlier case, particular case earlier in my career, I was asked to help bundle up some patent rights into a separate entity to be used solely as a trading hedge against a move into the US financial markets, where it was feared that there might be litigation and we might need something to bargain with. Having done some preliminary research, our client feared that there was a certain set of existing US patents which might be a future problem. Keeping our IP on one side from where it could be cross-licensed or used as part of a litigation settlement option proved ultimately not to be needed. But irrespective of the lucrative nature of the core proposition, as a means of convincing the board that the risks associated with the move could be substantially mitigated, it proved rather useful. There was also an entirely unplanned but welcome side benefit, such that later on, that ring-fenced company later became the platform for a licensing relationship for a joint venture, of which the company was just one participant. Now, I did reference earlier the opportunity to be somewhat negative, so let me deal with death and divorce. Starting with the death of a founder who remains a material shareholder in a company which has some valuable intangibles. Some questions to consider. How does he or she actually own the shares of the company where the brands are located? Is it directly, or is it through a separate company or series of companies? Once you've got the answer to that, to whom will the relevant shares pass on the death of that owner? And critically, have they been identified in a will? Now, I help a small but quite successful consultancy business run by two great lady entrepreneurs. It's been going a few years and they've got some great clients, but it was being run on the basis of model articles of association, having a deadlock board. They had equal remuneration, and there were no metrics about contribution of effort. So they were being paid the same, irrespective of what each other did. It was just a complete 50-50 business. They're the best of friends and they think on the same lines, but that's not always bound to be the case. So as part of looking at the general business operation, I encourage them to sort out a shareholders agreement, really as a backdoor mechanism for easing them into conversations about possible areas of disagreement and conflict. Now, one of those was about their relative contribution and how would that look in the event of a succession on death of one of the individuals. Would they be happy if the shares of that other party passed to a member of their family? Would the person inheriting those shares have an executive role? And that was as much a disguised way of asking if they would care as much about the business and therefore deserve to be a part owner, taking 50% remuneration for still what might be unequal effort. Would they be happy to be in business with each other's heirs? And that was a very interesting and delicate conversation indeed. Fortunately, as it turned out, having the discussion was incredibly productive. We amended the articles to ensure that shares could move to family members and avoided the potential hidden bear trap of having wills being in conflict with articles which trigger automatic preemption rights and countering, therefore, in favour of the other shareholders, thereby potentially countering the considered intentions of an individual's will. So suffice it to say that if relevant brands and intangibles are held in the same company as other operating assets, then it's entirely possible that the company's constitution will not allow shares to move where they're intended to go. And that's not to be done with malicious intent, but there can be material tension in the context of generational change. And managing it carefully ahead of an inevitable interview with your maker might ensure your portrait stays up in the boardroom rather than being shuffled off down the corridor somewhere less appropriate. Divorce, possibly better entitled relationship breakdown. Assets created by couples and held jointly, deliberately or otherwise, are inevitably susceptible to the consequences of such a relationship breakdown. On the theme of lockdown movie nights, after the Shawshank Redemption, can I bring to mind, and I'm conscious of the age of this, but the tale recounted by Danny DeVito in the 1989 classic with Michael Douglas and Kathleen Turner, The War of the Roses. And in that, Danny DeVito tries to ward off a prospective client who is looking to get a divorce by telling the story about how badly the breakup goes in terms of the management and separation of assets. So in any event, even if the management and ultimate direction of a settlement agreement might undo work to put assets into the hands of one or another party, work done to establish a baseline ownership for those assets, including taking advantage of the opportunities by the increasing use of and recognition of prenuptial agreements, can certainly be helpful. And as a practical example of how a basic step might be able to help, rather than being forced to sell the underlying rights and an underlying brand to a successful revenue generating business in order to raise capital for a settlement, having the option to only have to give up shares in that company would provide at least some choice. Moving on to matters more positive, succession and promotion. Who gets a share of the pie? So for companies where the offer of equity to senior management is an option, one of the questions which might be asked, do you want those individuals to benefit from growth in the value of the whole company? Or where there is a material brand or a material brand value, could that be hived off, again with the benefit of a license, such that promoted individuals only benefit from certain parts of the company growth? Now, if you're going to be inviting people to come and sit at the top table, it might be understandably viewed as divisive to retain certain rights in which those individuals may not now share or may never share. But where IP is of particular value to owners, or is being viewed as the source of some form of multi-generational family fortune, using a separate vehicle to own intangibles, which are then licensed to operating companies, provides at least an option for a tiered participation in a venture's success for those people being promoted. And in that way, the promoted individual shares at least in a part of the success, but just not all of it. The final scenario I want to look at is this issue of territorial expansion, where international opportunities beckon. Should the ownership of brands be treated differently? Well, some rights will cross borders, others are more rigidly drawn on geographic lines. For the sake of licensing programs, to make it as simple as possible to enter into contracts, holding the relevant rights in one single entity would make sense. Equally, there may be a case for moving them into regional hubs so they can be managed more effectively by those people in the closest possible markets. Now, the streamlining of global functions usually pushes the answer towards a single centralized function, where you have one single approach, one single budget, and a single enforcement strategy. But when you're in the context of situations such as parceling up divisions for some form of exit, then there is an opportunity to revisit that thinking. In all of the above scenarios, the opportunity exists to hold relevant intangibles either in another group company or outside the group altogether. And there are two parts to understanding the benefit of this. The first is that an operating company will generally have a limited liability status, and that means broadly that in any litigation, a contractual claim can only be brought against the counterparty to a contract and not against any other members of the group who are not party to that contract. So if you're not in that contract, in most situations, you are safe. The second related part to this benefit is something known as the principle of the corporate veil. And this means that courts will only allow a claimant to get around the first part and claim against related parties, where claimants can get over a double test, and that is the test of both impropriety, there's some form of wrongdoing, and that wrongdoing is linked to avoidance or concealment of a liability simply by using a company structure. And Kelvin was at pains to stress that taking basic structuring steps is perfectly legitimate activity. However, if as a claimant you can convince a court to pierce the corporate veil, you effectively lift up the curtain and see behind who's really pulling the strings, then you've got a chance to reach assets owned by third parties. But that hurdle that there must be impropriety or deliberate concealment means that undertaking the measures that, as I said, that have been discussed today is a perfectly legitimate tactic. What we're doing here is encouraging you to look at opportunities to openly move rights to be held in one place in return for an arm's length license. Those rights are then licensed back for exploitation through sales. And as Esther has described, those licenses will deal with situations involving insolvency and payment default by licensees. There's limited risk on the part of the owner licensor. Now, If the operating entities then suffer existential style threats, the licensing vehicle remains insulated from the event, and to be entirely dramatic about it, lives to fight another day. Think here about the Laura Ashley example that Esther referred to earlier. Many thanks also here to Stobbs Chris Murray, who in creating this visual has now left my 7-year-old utterly bemused and partly bereft by the fact that his father now tears arms off his Lego figures and hops around the room calling everyone a chicken. The fly in the ointment here is, of course, external investment. If you're going to ask people to put money into your business, they're going to, or at least they should be asking, where the value is. Now, if that value is locked into your brand, they'll want to know where that brand is. That doesn't mean you have to undo any structuring work. It just means you might have to give away or secure your business against bits you previously hadn't wanted to. Diligence which identifies the fact that intangibles might be held by a third-party entity into which investment is not being sought should not ruin that investment proposition altogether. Aside from demonstrating a particularly considered approach to the protection of your intangibles, and that should reflect positively on you as a potential counterparty or venture in business, flip this on its head and look at it from the angle that it creates a second investment opportunity and therefore enhances the overall and potentially the overall investment received. Can you use this to divide and conquer? So 2 examples of this. In terms of commercial lending, where security nets are thrown around assets of all group companies, the fact that assets have been moved into separate entities may require some explanation, but it doesn't need to alter the lending case. And in the investment context, where provided the separate vehicle is declared in the information memorandum or whatever other information is being declared by way of diligence, that's often viewed positively as a sign of prudent management. Now, it's a different situation, of course, if that separation is not declared and is left to be found through diligence, because that sometimes indicates a lack of good faith. It both looks bad, erodes trust, and tends to blow deals out of the water rather quickly. Now, by way of some concluding remarks, I'm keen to stress the importance of only taking steps that are proportionate to the rewards on offer and the risks that your business face. For every new company that you set up, there is necessarily further administration that comes with it. For those of you who've been through it, there's a reasonable analogy here with having children. Moving from 1 to 2 seems like an enormous change, but if you've already got several, you might say the incremental burden is perhaps limited. A number of you may already work within structures that have got a holding company sitting above the main trading entity. Have you thought about the possible benefits of moving brands up the chain to that company? Now, structuring decisions are necessarily strategic and require thoughtful planning. I think that's been stressed enough. While there's no pressure to do anything quickly, and comparatively, given the world we're in at the moment, if the sun is shining and there's time to mend the roof, allow me to badly mangle some metaphors and direct you back to the words of the White Rabbit. Spend a little time thinking about what you want to do with your brand and where there may be a better place to hold it. It may well be, of course, there is no significant benefit to doing anything, and that's fine. You may just be happier knowing that you have thought about it. Thank you very much for your kind attention. Be happy to take questions as well as to see some of you for a quick drink afterwards. It's obviously not a popularity contest, but there is a side bet going on between the panelists.
Well, hopefully it's not skewed too much, the fact that people have to just stay in the same room to actually talk to Julius, but exit and go elsewhere to talk to the other panelists. But we'll see how it goes. Rupert, thank you so much for a wonderful presentation there. So we've got a few questions that have come in, but first of all, let's go back to Eric's first question. Eric, like right at the beginning of the summit, asked the question, doesn't transfer of brands trigger significant transfer pricing and tax issues? Do you feel that you've dealt with that one there, or is there something that you'd like to add to that?
Well, I think it's perfectly clear everything needs to be judged in its own particular context. But necessarily, if you are moving brands from one company to another, that transfer of value needs to be recognised on the relevant balance sheets. That goes back to issues of brand valuation. For that, Fernando and Kelvin can certainly help and may have some comment in their direct Q&A afterwards. But from my perspective, yes, there is going to be a tax charge which will be triggered on the move. And so in the context of moving in young businesses, one would expect that the brand value is going to be comparatively lower, and therefore that might be seen as a good time to take the step. Moving brands at a later date depends very much on whether or not there is a significant benefit in moving the intangibles to the destination jurisdiction. And I mentioned before, places like Ireland have spent a lot of time trying to keep their corporation tax rates low, particularly in the context of intangibles-led businesses. So looking at those, I think, is looking at the cost issue is very much one that is aligned to the comparative maturity of the brand.
Interesting question just in from Gillian, saying, if you have existing lending secured over all assets of the company, what is your experience of those lenders approving a reorganization of the intangible assets?
I don't have any direct experience of people reopening security nets in order to undertake restructuring, unless there is, undertaking simple restructuring per se. If you were able to go back to lenders and say, there is a specific reason that we are looking to restructure, and that is in order to create a platform for, say, a licensing program, then I can't see why commercial lenders would not want to extend the net. They would necessarily want to make sure that everything was captured and nothing was leaking. But and if you're not changing the asset base against which the security is made, so ordinarily there ought not to be a reason why they would say no. Not to say that they wouldn't perhaps extract another fee, but I'm afraid that's lenders for you.
Another question. You said that you were using brands as a shorthand for intangibles generally. Can structuring work for any types of IP rights?
Yes, it can. There are certain IP rights which need to be held in relevant jurisdictions. Thinking on PCTs and Madrid rights. Perhaps Julius might be able to pick that one up at a later time. But it can certainly. There is usually some tension around trying to do it with personal data, largely because you get caught up in definitions of controller and processor, and at that point in time, creating the paperwork chains in order to ensure that the necessary title is in place is difficult. But from otherwise, looking at any other types of intangibles certainly works. Copyright, trademarks, patents, designs. That's all ripe for structuring.
And just time for two more questions. So firstly, for an established business, how realistic is it to move IP around? What about established contracts, and how is this sort of activity perceived by clients and counterparties?
So for established brands, is this viable? I think it is viable, particularly in the context of looking at going into brand extension. If you're moving into areas that you haven't previously looked at, if all you are doing is moving brands within the context of an existing, let's say there's an existing licensing program, it is possible to amend the paperwork. It's not always obvious. It does need some explanation, and at that point in time, you can expect existing counterparties to ask some pretty challenging questions, because what it will necessarily do is limit their rights should there be some form of default on the part of the existing licensor.